Welcome to Just Liberty, where justice and liberty meet. I'm Bettina Krause, editor of Liberty Magazine. Here with me is my co-host, Alan Reineck, executive director of the Church State Council, and together we're trying to recover religious liberty from the political extremes. So, hi, Alan, how you doing?
I'm doing great, and we've got a great topic today because we're really talking about free speech on campuses and religious speech. And, I think one of the things that I certainly want our listeners to understand, Bettina, is that all these rights are connected.
Mm-hmm.
In fact, I did an article for Liberty Magazine some years ago entitled "No Right is an Island." Think about when you go to church, you're engaging, the preacher's preaching, so there's free speech. In the post-COVID era, we're all kind of broadcasting on YouTube, so the shut-ins can listen. So now that's another form of free speech. It's broadcast. We're assembling together, right? Obviously we're also practicing our religion. So we've got religious freedom, we've got speech, we've got assembly, we've got all these freedoms together, and yet somehow Americans increasingly think it's okay for me to have my free speech, but not for you.
Yeah, and that right there is the problem, where free speech has gone from being a principle that and a right that applies to everyone to being something that we want to limit based on whatever view is being expressed. In fact, what caught my attention recently was an article that was talking about a recent poll that showed that students on America's campuses are really misunderstanding what free speech is all about. In fact, only 1/3 of them affirm that it is never, ever acceptable to shout down someone else's speech. So there is sort of a foundational misunderstanding happening here about what free speech is.
We're seeing those episodes on very prominent campuses.
Right.
Harvard last year, Stanford
Yeah.
earlier this year. And one of the things that I found amusing in the article is that Harvard itself, which, ought to be kind of a leader on, as one of the nation's, foremost campuses, it's at the bottom of the list. It's rated abysmal for its free speech performance, I guess.
Which is absolutely stunning. But it's stunning, but it's not surprising. Because, when I read that article, my thought was, this is not new. Americans have always had sort of a troubled relationship with free speech. I mean, you think of way back when the Bill of Rights was ratified, 1791. Just 7 years later, President John Adams passed the Seditions Act, which is basically a government repression of speech with which it disagreed. And so, we have, I think, long struggled with what free speech is, and we've given into our human impulse to sort of want to squash people who are not speaking in ways we agree with.
Yeah, look at the McCarthy era and
Yes.
the blacklisting of communists, and I'm putting that in quotes here because some were and some weren't, but we've had all kinds of cases over the years in the Supreme Court challenging restrictions on free speech.
Right, and even in this current era, you think of the ACLU, which is like this bastion of supporting free speech. I was interested to read recently an interview with a former executive director of the ACLU who is basically saying that attorneys with that organization are now being told that they should not support speech that does not align with progressive values. In other words, some speech is not acceptable. I mean, and this is for an organization that historically has defended flag burners and Nazi marches. So we have to, I mean, the understanding what free speech is and that it embraces uncomfortable speech, I think is absolutely vital for all of us.
Freedom for the speech we hate. I
Yeah.
want to say that was Anthony Lewis's fantastic book, former speechwriter, I want to say for Richard Nixon, New York Times columnist. Um, Very readable book. I highly recommend. I may not have gotten the title quite right, but yeah, fantastic. Well, our discussion today is going to go to free speech and religion in the context of high school clubs and what's happening at the high school level. There's been a lot of litigation in recent years about free speech on college campuses. And I will say our colleges really have a lot of work to do. The speech codes, that they want to enforce in the name of civility, are very blatantly unconstitutional. You can't punish people for using the N-word. You can ostracize them if you choose to, for engaging in speech that is offensive and rude. But we're allowed to be offensive and rude. We're allowed to be obnoxious. I know, I'm from New York. I come by it naturally.
You test those limits, Alan.
Not so much anymore. The Holy Spirit got a hold of me.
Well, I don't know. I think it's time to bring on our guest. What do you think?
Let's do it. Well, I'm very happy to welcome an old friend, attorney Kim Colby, who is of counsel for the Christian Legal Society Center for Law and Religious Freedom. And she's worked for CLS since law school, Harvard Law School in 1981. Kim has represented religious groups in a number of appellate cases, including two heard by the U.S. Supreme Court, and very much involved in the legislative advocacy work of the Christian Legal Society, of which I have been a proud member since law school, and always happy to put in a plug for the nation's foremost association of Christian attorneys. Kim, thanks for being with us today.
Well, it's a pleasure to be here. Thank you, Alan, and to what?
And we're celebrating with you a very important win in the Ninth Circuit U.S. Court of Appeals, which covers a whole host of Western states, including California. Tell us about the Fellowship of Christian Athletes case.
Okay, just briefly, the Fellowship of Christian Athletes is a national organization that's been around a long time, and it has chapters on college campuses and in high schools, student chapters of mostly student athletes who just want to get together and either share their Christian faith or talk about their Christian faith. Anyone is welcome to come to FCA meetings, but FCA requires that its leaders share its religious beliefs, be Christians. And one of its beliefs is that marriage is between a man and a woman, which, of course, wasn't controversial when FCA began, but has become more controversial. So this particular chapter was meeting in a San Jose Unified School District high school called Pioneer High School. They'd been meeting for several years without any problems. But one day, a teacher, AP U.S. history teacher, posted on his whiteboard what he thought were the religious beliefs of the FCA. And next to it, he wrote, "It saddens me that a group that meets on this campus requires its members to agree with these religious beliefs, or these beliefs. How do you feel?" That's a paraphrase. It's not an exact quote. And of course, he was wrong about members being required to agree with the beliefs, just the leaders were. But two of the leaders of the FCA were actually in his class, and they were appalled to see their group's religious beliefs being posted on the blackboard in an unfriendly manner by this teacher. So they spoke to him afterwards. The long and short is that in 10 days, the school climate committee had decided that these beliefs didn't belong at Pioneer High School, and the principal had derecognized the FCA group as a club. And What that they said you can still meet on campus, but you're not an official student group and you don't get certain benefits that other student groups get. And so this was the end of one school year. At the beginning of the next school year, the FCA said, hey, can we be recognized this year? And the school said, no, you can't be recognized. But the school did recognize the Satanic Temple Club, which was its first time on campus. And one of its purposes seemed to be to meet outside the FCA student groups' meetings and protest them. And so life became very difficult for the FCA leaders. These were two young women who just were wonderful women. It was their senior year, and they just had a really hard time that year. So after trying to convince the school district to do the right thing, after about a year, they were in touch with some lawyers who were in touch with us, and CLS ended up filing a lawsuit on their behalf.
So, Kim, the issues here seem to be both religious freedom and freedom of association. But can you place the sort of the facts of this case within a broader context of what's been happening in these two areas within the law over the past decade or so?
So a couple of things. One thing is there is a federal law that the Seventh-day Adventists were instrumental in with CLS and a couple of other groups in getting passed in 1984, which is a long time ago, called the Equal Access Act. And the purpose of that law was to keep religious student groups on public high school campuses. And, I enjoyed so much working with you all, and we thought we solved the problem. So there's this law, and that's a lot of the time before we filed a lawsuit, we kept saying, hey, you school district, you need to follow this federal law. You can't exclude the religious student group from campus. And so that's one part. There's this longstanding law. But then, of course, as we all know, the Supreme Court has been doing quite a bit to strengthen free exercise and free speech in the past decade. And so that, too, became part of the Ninth Circuit's positive decision. So just very shortly, the case we lost in the district court, but then we appealed to the Ninth Circuit. There's a panel of 3 judges that hear cases on appeal in any circuit. And the Ninth Circuit covers the West Coast and some of the interior Western states. But anyway, we appealed to the Ninth Circuit. We had a 3-judge panel, 2-1. It ruled in favor on pretty narrow free exercise grounds for the FCA students. We were really thrilled. But the school district decided to roll the dice, and they asked for an 11-judge panel of the Ninth Circuit to hear the case. That's very unusual, but the Ninth Circuit agreed to do that. And this time, 9-2, we won. Before that, 11-judge panel on much broader grounds. We won on free exercise 3 different ways, as well as free speech.
Listening to this story, Kim, one of the things that makes me sad is how hard you have to work to get the federal courts to recognize what, if it were a snake, it would bite you. It seems like such an obvious case of religious discrimination, and yet it's so difficult to get federal judges to wrap their brains around religious discrimination. Do you have any perspective on why that might be?
Well, Alan, you live in the Ninth Circuit and you practice at the Ninth Circuit.
I do.
One of the wonderful things about this case, in the past, the Ninth Circuit has been considered a very difficult place to be on religious freedom or religious speech cases. It's not that we've always lost in the Ninth Circuit, but we lose more than we should. And that's, I guess we could say, just who the judges are a lot of the time. Their predispositions are not necessarily friendly to religious freedom. But I hate to paint with that broad a brush, but anyway, we all know the Ninth Circuit's been a bad place to be a lot of the time, and that's changed somewhat. And this case is a really good example of how, when the judges do get their minds wrapped around what's really at stake, they can do such good, because this panel of 11 judges overruled a bad decision that had been hurting religious groups on college campuses for 10 years, the Alpha Delta Chi case. And they also made very clear, like I said, it's a very strong opinion, that religious student groups have the right to require that their leaders agree with their religious beliefs, and they can't be excluded from campus just because they're doing that. So I think it's really remarkable that the Ninth Circuit's gone from a difficult place to be for religious freedom to, with this decision and many others, and actually a pretty good place to be.
So, Kim, I'm going to play devil's advocate for a moment, because there may be some people listening who say, hey, we live in a pluralistic society. Values such as protecting folk against discrimination on any basis, I mean, that's important. So how do we answer that in this context of, free speech and religious freedom on campuses? How do we protect both values?
Well, a couple of things. So the court was very consistent in reaffirming how important non-discrimination policies are in our society. But I think when you look at this case, and what the court said is, no student of any faith should be afraid to go to school and think that their religious beliefs are going to be disparaged by their teachers, the school newspaper, the administrators, the climate committee. And so that's why this decision is so important. It's an evangelical Christian group at issue here, but it actually protects students of all faiths. No student should be afraid to go to school because they think their religious beliefs are going to be disparaged. So there's this balance in a pluralistic society, and I think the court was very aware of that and reaffirming that, yes, we want to protect against discrimination, but religious discrimination is just as bad as other types of discrimination, and it's, as we all know, it's a historical, very strong form of discrimination. And so in this situation, we look and we say, the religious students have their right to have their religious beliefs, and we can still protect the other students, but we have to also protect the religious students.
I want to know about the impact of all of this on the kids and their experience. Was this, what did this do for their faith and for their experience at the high school? Were they marginalized because they stood up for themselves? What was their experience like?
So I am in awe of my clients and the students who continued to attend FCA during the 4 years that this was at issue. The two clients who were initially involved, the two plaintiffs originally, Elizabeth and Charlotta, they're about to graduate from college. And so a lot of the pain that was inflicted on them, there's still pain there, but it has, they've been able to put some distance, both physically because they weren't at the school, and then emotionally as they've gotten older. So they're doing very well. But the chapter itself, the students who kept standing up and going into the breach to continue the club, because the school district's main mode of attack was to try to just completely destroy the club. Because, Alan, as you know, if they could completely destroy the club, then they could claim, and they did in court, that there was no club and therefore the case was over. There was really no relief that the court could give. And they didn't do that. There were, every year, new students came up and they said, we will help with this unpopular group, knowing what they were facing. So they're really amazing. And last spring, after the first preliminary injunction, they did have a meeting where they invited as many students as wanted to come to hear a speaker. That's what FCA does. They bring in sports people to speak. And they had a very good turnout. So it's really, it's both discouraging because these are the worst facts I've ever seen in 40 years of working on these types of cases. But also they've held on. They've held on. And I think now that they're really protected by the court long term, I think they're going to thrive.
Kim, I'm interested what you, in your role as with the CLS, I mean, what do you tell students who are having trouble with this sort of thing? Because we're seeing these speech issues crop up in so many different contexts, so many different schools and universities. What do you tell them? How do you clarify what their rights are?
Well, usually, I mean, what I tell them is you have this federal law and you have the First Amendment. So find out what the school administrator's problem is and educate them, and we give them the materials. And sometimes that's all that it takes. But sometimes it's not enough, and then we'll write a letter to the school administrators laying out what the legal landscape is and why they have to allow the religious student group to meet. It's unusual that it has to go to litigation because the law is really pretty clear. And the law actually, Alan knows this, but there have been a couple of cases in the Eighth Circuit, which is the middle of the country, where they've said to university officials at University of Iowa, you knew the law was clear and you went ahead and derecognized the religious student group. And so now you have to pay out of your own pocket the damage that you did to these groups. So that's those two decisions came down in 1921. And I think that's going to also help.
You mean 2021? You said 1921.
Oh, gosh.
I know you've been doing this a long time, Kim, but not quite that long.
2021, yes. But anyway, so yes. That's what it came down. And I think those decisions are also going to be more helpful in our letters because administrators kind of pay attention when the money may come out of their own pocket.
Oh, absolutely.
So that's what we're doing. But what you really want, what we really all want, I think, is a return to a culture where just everyone's religious beliefs are respected. And even if you just, where the idea is you can disagree and still respect other people's rights. That's what we need to get back to. And I think many of us, we are watching what's happening in our society, but also on our campuses. And that is not being taught enough. That, yes, you may disagree with other people, but you respect their rights. They respect your rights. Freedom of speech, free exercise of religion, protects all of us.
Well, and to put this in the larger context, there's a huge movement within the business community to do training on what's called DEI, diversity, equity, and inclusion, and even to hire staff whose responsibility is to do this kind of training and policies and what have you. But too often, religion is left out of that equation. And I think, somehow we need to make a dent to say, yes, equality and inclusion and diversity has to do with race, and it can be, recognize gender identity issues and all of that, but you can't leave religion out, that the same principles apply across the board. And certainly there is, in the culture war context where, the left and right are battling, those of us battling for a sort of, respect for both left, right, and center and every way around are kind of, well, I call us the lonely middle.
Well, I think this kind of goes back to my 1921 clip, but I think a lot of us that grew up in the 70s and 80s and even the 90s, I mean, the Clinton years were golden years for religious freedom and even for free speech. We take for granted that everyone understands the need for us to respect one another's speech and religion. And we've somehow seemed to be losing that in the more recent years. And we've started, I think, articulating ways to help the people who are younger understand that you have to think for yourself and you have to start listening to what other people are saying. And they may not change your mind, but you have to respect that other people can think differently from you. And I think that's, with even like what you were just saying, a lot of these programs, they make assumptions, many of which are good and many of which are necessary, but they have left religion out of the equation of diversity.
And I think that piece of education is absolutely crucial in engaging with this issue going forward. We could continue talking about this all day. I sense some future conversations that need to happen. Thank you so much, Kim, for taking the time to help us understand what this case was about, but also the implications of the outcome of this case going forward. So thank you. We really appreciate it.
Well, it's been a real pleasure, and I can't let go without saying that Alan played a critical role at a couple of critical points in this case, but he's too modest to take credit. But, we're in your debt, Alan. So thank you both for letting me talk about this important case.
Well, I sure appreciate you reaching out to me and giving me a chance to help out.
What a great interview, Alan. I mean, she really helped us understand what that case was all about.
Kim has been working on these issues of student clubs and access in the public school literally her entire career. You heard her say since, 1984, when I was beginning my law school career. Christian Legal Society, this has been one of the issues that they've really championed over the years. And if you think about it, there's all kinds of clubs in high school. You've got the ski club. I was a member of the chess club. You've got just dozens of clubs, and to say, well, you can't have a Christian club, or that you can't have people who are actually Christians or believe, to lead the club, it just doesn't make any sense.
It's so interesting, Alan, the point that you raised about the need to educate people about religious discrimination, and especially in workplaces where they have these elaborate education schemes for other categories, other protected categories, but religion gets sort of left off the list. I don't know I'm sure you've heard, of course, of Brian Grimm and his foundation, the Religious Freedom and Business Foundation, and he is trying to do exactly that, which is to bring religion into the fold of, race and other identity characteristics
within the corporate workplace.
Exactly. We need that not just in the corporate workplace. We need it in every sector of society. We need that sort of education.
The broader issues of free speech and religious speech are really having a heyday on the college campuses, where left and right alike have been increasingly intolerant in shouting down or objecting to viewpoints presented by those on the other side. So there really is there's a real need in our culture for us to recognize that it's okay to disagree. But other viewpoints are allowed to be heard. That's kind of basic, but we're losing that.
Yeah. Yep. Dissent is not a dirty word.
Yes. Well, I like to be, I pride myself on being a contrarian.
This has been Just Liberty, where justice and liberty meet. I'm Bettina Krause, here with Alan Reineck. And until next time, remember,
Eternal vigilance is the price of liberty.